Now, when it comes to international arbitration, the primary advantage of international arbitration over court litigation is enforceability, because an international arbitration award is enforceable in most countries of the world. There is a treaty called the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, what we usually refer to as the New York Convention of 1958. And what the treaty says is that if you sign on to this treaty, if a state signs into the agreement, ratifies the agreement, then courts in that state must respect arbitration awards, meaning they cannot go back and look at the subject matter of the dispute. If it has been arbitrated, they must enforce the award. They must require the losing party to pay. The winning party will win. Now, because of this emphasis on enforceability, virtually every significant commercial country in the world has joined this convention. So wherever our dispute arises, if I am in Kansas and I have a dispute with a Chinese company or with a French company or with a Korean company, almost certainly those states will all recognize a foreign arbitration award. So even though we've had the arbitration in Kansas, if you are doing business in China, I can take that award, go to China, go to court, and have the Chinese court require you to obey the words of the arbitration panel. So the primary advantage of international arbitration over litigation is enforceability. Now, can you enforce a foreign judgment that you got out of a foreign court in a different country? Maybe. Much more difficult to do so, however. Much more difficult to establish the enforceability of that. Generally, courts, when faced with a foreign judgment, they have the ability to go back and revisit the original subject matter dispute and to revisit the fairness of the underlying court system. That doesn't exist in the context of arbitration. So arbitration, often used for the resolution of commercial disputes, particularly in the international context. And as I said, in certain countries such as the United States, arbitration is found everywhere. Your cell phone agreement, your credit card agreement, your iTunes license agreement, all of those include an arbitration clause, whether you are aware of it or not. Now, what are the other advantages and disadvantages of arbitration? Well, again, saving time is a huge part. Now, I cannot save as much time as with negotiation or even with mediation, but arbitration will move much, much faster than litigation. I can get a court, whereas with negotiation, I can pick up the phone and do it today, or through mediation, I can have a mediation within the next 2 weeks. With an arbitration, you can have an arbitration within a couple of months. So a huge advantage in terms of saving time. Saving money, again, you won't save as much as you would with negotiation or mediation, but you're going to save a lot off of litigation, in large part because your attorneys are going to be working much fewer hours because of the compressed time period. Furthermore, because there is no appeal, you don't have to be concerned about endless appeals of a decision. Flexibility. Again, unlike litigation, the parties can agree on the rules themselves. They can use whatever rules they want to use, and they can put in whatever time limits they want to put in. They can provide for the discovery of evidence from either side. Very flexible methodology. Expertise. Again, we can select arbitrators who are familiar with our particular situation. Unlike a jury, where you've got to spend a lot of time educating the jury, or sometimes you have to educate the judge if the judge has no background having to do with your particular industry. With an arbitrator, we can select people who are familiar with this exact type of dispute. And so if we have a dispute over whether goods conform to those named in the contract, to the terms of the contract, we can find an arbitrator who is a specialist in that area. It has other advantages. Again, neutrality. If I am concerned about having a case brought in a foreign court and the other side is worried about that, we can choose a third country, a neutral ground. It's confidential. Now, the arbitrator, the arbitration panel will be aware of what the source of your dispute is, but no one else. Unlike litigation, which is open to the world, arbitration still confidential. And as I mentioned, enforceability, of course, a huge advantage. Availability of institutional help. What this means is there are companies that are in the business of facilitating arbitration. They are there to assist parties. They can provide a preset number of rules. They can provide arbitrators that are responsive to your exact needs. There's a large amount of institutional help that's available for an arbitration proceeding. Mitigation of hostilities. What this means is the advantage of arbitration is this idea of finality. Meaning you and I get into a dispute, we've done business for years in the past, and now we have a dispute. Well, if we arbitrate it, that dispute can be resolved within 2 months. We can be done with it and we can go back to our previous relationship. Whereas if we're involved in litigation for 5 years, we're not going to be doing business in that interim period. So having arbitration being quick and having it final can help to mitigate hostilities. Now, there are disadvantages as well. First of all, without parity between the bargaining power of the parties, it is possible for unfair procedures to be put into place. I mentioned that arbitration appears in any number of consumer transactions or employment agreements. One of the major criticisms of arbitration is that those decisions, those procedures that are going to govern your arbitration, they're going to be determined not by you, the consumer, or you, the employee, but by a large company, the company that you're doing business with, or the company who employs you. And so without parity between the bargaining power of the parties, it's certainly possible for unfair procedures to be put in place. Because most arbitration awards are confidential, it's also difficult to determine how is your particular dispute going to be resolved. Unlike with litigation, where it is a public matter, a public record is created, it can be difficult to evaluate a case because you don't know how similar cases are resolved. One of the beauties of the common law is this idea that cases are determined in public setting. People know what the cases are. And so if a situation with similar facts appears, then the parties will be able to know or have some general idea of how that is often going to be resolved. Very difficult to gauge those matters in arbitration. What that means is that you may not be fully aware of the risk that you are facing in an arbitration proceeding. It may exceed what you thought was the potential downfall. There's other disadvantages, and again, this idea of no appeal. It can work in our favor, right? It can lead to a mitigation of hostilities. It can lead to a rapid resolution. But it also means that the parties are bound. And if you have an arbitrator or an arbitration panel that simply gets it wrong, there is no ability to go out and appeal that to a court. There is no neutral third party that's going to evaluate the fairness or the accuracy of the arbitration. So no appeal means no appeal. You are bound by the results, even if the procedures were unfair, or even if your arbitrator got it wrong, or you think they got it wrong. Another disadvantage of arbitration kind of goes back to that point I was making earlier. It sort of prevents the flow of information and expertise, meaning the information that's out there tends to be caught in these little containers, these private containers, and does not enter into the open flow of discussion. So we don't know how cases are being resolved. We are unable to gauge our potential risks, our downfall, because we don't have that information, because it's locked away in a confidential proceeding.